We have to talk about history if we're going to talk about protecting our right to keep and bear arms under the Second Amendment. Today I'm going to explain a particular argument that I think we should be making more of in the context of these anti-gun post-Bruen decisions by places like New York State that have enacted laws specifically to get around and to undercut the Supreme Court's decision in Bruen from 2022. Let's talk about all of this when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say a top 5 finalist in 2 separate categories for the 2024 Gundy Awards for prominent people in the context of YouTube and the Second Amendment. The first category that I'm a top 5 finalist is top male influencer in the Second Amendment space, and the other category is top voices of the Second Amendment. I am proud to be nominated and a finalist in both categories. All right, folks, so here's the story. I'm going to give you an argument that I want you all to start thinking about and maybe using a little bit more, especially lawyers out there fighting these Bruen response laws, especially sensitive places laws that have been enacted by anti-gun states such as New York, California, New Jersey. People like Kathy Hochul and Gavin Newsom. A particular argument I want to flag that I don't think has necessarily been made as much as it should have in courts and perhaps in the court of public opinion. Just as a reminder, in June of 2022, the U.S. Supreme Court issued the NYSERPA versus Bruen decision, which was really a reaffirmation of the 2008 Supreme Court decision of Heller versus the District of Columbia. And again, Heller and Bruen both relied extensively upon history. As we know from Heller and then Bruen, the way Second Amendment analysis works is this. You read the text of the Second Amendment, the right of the people to keep and bear arms shall not be infringed. To the extent a modern-day gun control law is implicated by the text of the Second Amendment, that gun control law is presumptively unconstitutional. That gun control law is presumptively unconstitutional, and the government is presumed to lose the case. In the same way, in a criminal trial, you are presumed innocent, and the government bears the burden to come forth to demonstrate that you have committed a crime. So, too, once the Second Amendment text is implicated by a modern-day gun control law, the burden is on the government to justify that modern-day gun control law. And the only way the government can satisfy its burden of proof, if you will, to justify that modern-day gun control law is to come forth with actual laws, regulations that were on the books at the time of our founding when the Second Amendment was adopted in 1791. And again, the first criteria here that the government has to meet is that it has to come forth with actual laws. Now, those laws can potentially be federal constitutional provisions. It could be state constitutional provisions. It could be common law, which are, back in the time is judge-made law, which is an English tradition, meaning, decisions by judges can constitute what's known as the common law, and judges build upon other judges, and judges learn from other judges in the form of common law, or it could be statutory law. These are the sorts of actual laws on the books that the government has the burden to come forth to actually show exist. The government cannot, despite their best efforts, simply claim that historians say that the Founding Fathers would have approved of a particular kind of gun control law, even though they were never enacted. That is a no-go zone. The Supreme Court has made it clear in Bruen that if there's a particular kind of problem like street crime in a city or street crime or terrorism, whatever it is, and the Founding Fathers decide to address that with something other than gun control, that is proof that a modern-day gun control law that seeks to address that same problem today is unconstitutional. And keep in mind, as an example of this, at the time of the founding, whenever a place was a particularly endangered place because, let's say, they feared that a church might be attacked by Indians, well, guess what? In that case, they did not put up a sign that says tomahawk-free zone or knife-free zone or gun-free zone and pass a law that said the same. No, indeed, what the Founding Fathers did is they actually asked people to bring firearms to those quote-unquote sensitive places such as churches to make sure if they were attacked by criminals or Indians, people would be able to shoot back. That's an example of a problem that existed in the 18th century that may exist today, i.e., places being attacked by bad people with bad intentions about hurting people. But the way the Founding Fathers addressed it was more guns and requiring people to bring guns, as opposed to, let's say, what certain anti-gun states do, which is to ban guns, with just saying no guns allowed, as if criminals or anyone will comply with that if they want to violate the law of murder. Okay, so what exactly, in addition to having to find an actual law, also known as a historical analog law, on the books, the anti-gun states, or the blue states, or the states that are trying to justify gun control law today using history, have to show that if they are able to find a gun control law at the time of the founding to justify a modern-day gun control law today, the 21st century, the Supreme Court says that the two criteria that must be met is the why the modern-day gun control law was enacted has to be the same as the why the 18th century gun control law was enacted, and this is conjunctive, meaning you have to have both why and the how the law was enforced. An example of a why problem, where the anti-gunners try to use a why, but it doesn't satisfy the Supreme Court's Bruen decision, is again the thing we've talked about before, which is gunpowder laws that limited you to the amount of black powder you were allowed to have in a home in cities like Boston and so on, because the why you had limitations on black powder at the time of the founding was a fire concern. It was fire safety. It had nothing to do with crime whatsoever. In contrast, today in the 21st century, anti-gunner laws restricting, let's say, magazine capacity for semi-automatic firearms, those laws the anti-gunners try to justify by saying, well, see, we could restrict black powder at the time of the founding, so therefore we can restrict the number of rounds you have in your magazine today in the 21st century. But the whys are different, you see. The why in the 18th century was the why of the law being enacted was to prevent fires and the burning down of a city because of fires. The why the anti-gunners are enacting magazine capacity laws is allegedly because they don't want criminals to be able to abuse firearms, or because they want to infringe upon the rights of law-abiding Americans. But either way, the whys don't line up. Now, there's a particular point that I think is extra useful here when you're dealing with these laws that were enacted immediately after the Bruen decision. And I think a classic example of this is New York's laws, specifically New York's specific response to Bruen, because on July 1st, 2022, right after the Bruen decision was decided in June of 2022, New York Governor Kathy Hochul issued a proclamation that convened an extraordinary session of the New York State Assembly and the New York State Senate to consider gun legislation in light of the Bruen decision. Specifically, according to reports at the time, I'll put the link to it down below. I'm sure many of you are familiar with this. There was sweeping legislation that was enacted to address the impact Bruen would have on the increase of number of people in New York carrying guns. And one of the biggest things, of course, was they dramatically expanded the number of sensitive places, i.e. government-mandated gun-free zones, from very few in the state of New York in 2022 to a huge number of them today in 2024 and, of course, in 2023. We understand, and this is what the point I want to make. It is very important that whenever you see these laws that were enacted after Bruen, that when you talk about the why the laws were enacted. What will happen, for example, is that in the context of fighting over quote-unquote sensitive places, or, again, government-mandated gun-free zones, they're the same. Sensitive places are the euphemism of that. The anti-gunners are going to argue that the why these things were enacted was to stop or thwart criminals. But the first argument that the Second Amendment community should be making is the why these laws were enacted by states like New York, California, New Jersey is specifically because they wanted to get around Bruen. These were in response to Bruen, and the problem that they were trying to address is specifically that these states did not want to comply with Bruen. So they were looking for an end run around Bruen. And therefore, of course, the why these laws were enacted in the 21st century is specifically that a state wanted to get around a constitutional amendment that was being enforced by the U.S. Supreme Court. So why these things were enacted in the 21st century will not line up with any laws from the 18th century in 1791, because you're not going to find any historical analog laws in the 18th century or the early 19th century, for that matter, that it was on the books as an attempt to stop or thwart a Supreme Court precedent that sought to enforce a constitutional right in any respect. Certainly anything that touches fingers with gun control, or even crime control for that matter. So again, the first argument when you're dealing with a constitutional challenge against these modern-day gun control laws enacted after Bruen is to point out that the why of today's law by Kathy Hochul, by Gavin Newsom, by the governor of New Jersey, the why of those modern-day gun control laws simply cannot be justified by the why of any laws enacted in the 1791, because there are no laws in the 18th century where the why was to get around a constitutional amendment and or Supreme Court precedent enforcing that amendment. And I think this argument works particularly well in the context of the sensitive place fight, because just think about New York State for a moment. So here you have a place like Times Square in Midtown Manhattan that for over 200 years was not viewed to be a sensitive place, or there's no reason for there to be a government-mandated gun-free zone at all. Same with all these other places in New York. For over 200 years, none of these things were designated gun-free zones by the state. Only when Bruen was decided that all of these things miraculously become government-mandated gun-free zones. Was there a rise in crime between June of 2022 and the fall of 2022 when a lot of these laws were enacted? No. Was there any kind of danger or any new issue or anything at all? No. The only difference was the U.S. Supreme Court's decision in Nysurper versus Bruen. And this, again, means that the whys are not going to line up. And because the whys don't line up, they are not enforceable. Because, again, the only historical regulations that can be considered are those where the how and the why are analogous to the modern-day gun control law, and the how and the why of the 18th century law, again, lines up with the modern-day gun control law. And even if you have that, mind you, the anti-gunners have an obligation under Bruen to come forth with more than one. Keep in mind that in Bruen itself, the U.S. Supreme Court rejected three founding-era laws. There were supposed Statute of Northampton analogs. The point being that three laws at the time of the founding was viewed as not sufficient to justify a 21st century gun control law, which means it seems just off the top of one's head that the anti-gunners, to justify a modern-day gun control law, have to find an actual regulation at the time of the founding. The how and the why are satisfied, and there has to be more than three, because this is what the Supreme Court said in Bruen about the three laws that the anti-gunners came forward, New York State came forward in Bruen. The Supreme Court wrote, quote, "In the colonial era, respondents, which is New York State, point to only three restrictions on public carry. For starters, we, the Supreme Court, we doubt that three colonial regulations could suffice to show a tradition of public carry regulation. In any event, even looking at the laws on their own terms, we are not convinced that they regulated public carry akin to the New York law before us." So there you have the Supreme Court saying that three colonial laws or three colonial regulations are not sufficient to show a tradition of public carry regulation, meaning you're going to have to come forth with more than three laws on the books at the time of the founding today to justify modern gun control law. And then again, the Supreme Court went on to say that those laws did not line up and were not analogous to New York State's May issue permitting regime because they were not analogous. Yet another reason why Bruen knocked out those New York May issue laws. The other thing to keep in mind is the Supreme Court specifically did reject the notion that a single law, not only was three laws not enough, but a single law was not enough, because they elaborated on this point. What the Supreme Court went on to say, really to point out that outlier laws are no good, is the Supreme Court says, quote, "We have already explained that we will not stake our interpretation of the Second Amendment upon a law in effect in a single state or in a single city that contradicts the overwhelming weight of other evidence regarding the right to keep and bear arms in public for self-defense." So again, one law, two laws, three laws is not going to be enough. Certainly anything they grab out there is just simply not going to be enough to justify modern-day gun control law. And mind you, and I keep reminding everyone about this, I think this keeps getting lost but we're going to keep bringing it back, and that is the power of footnote number 11. Footnote number 11 in Nysurpa versus Bruen is extremely good for the Second Amendment community, and I will wrap up with this point. If you look at footnote 11 of Nysurpa versus Bruen, it talks about how if there is any kind of ambiguity, which means there's multiple reasonable interpretations of the historical record, where, remember, the burden, once the text is satisfied by the pleadings, the burden shifts to the government to come forth with historical analogs, laws on the books at the time of the founding to justify the modern-day gun control law. And again, footnote 11 says that if there's any argument about what the historical record means, is there any dispute or questions, then the presumption goes in favor of freedom, in favor of the unqualified command of the Second Amendment. So in footnote 11, the Supreme Court writes, quote, "The dissent discounts the Sir John Knight's case because it only arguably supports the view that an evil intent requirement attached to the statute of Northampton by the late 1600s and early 1700s. Goes on to say, the Supreme Court says, but again, because the Second Amendment's bare text covers petitioners, meaning the plaintiffs, public carry, the respondents, which is New York State, the respondents here shoulder the burden of demonstrating that New York's proper cause requirement is consistent with the Second Amendment's text and historical scope." And here's the key language. "To the extent there are multiple plausible interpretations of Sir John Knight's case, we will favor the one that is more consistent with the Second Amendment's command," period, close quote. The point being, footnote 11 says that if there are multiple plausible interpretations of the historical record, then freedom prevails. The text of the Second Amendment shall not be infringed wins. That's why the court says, quote, "We will favor the interpretation, the one interpretation that is more consistent with the Second Amendment's command." And what exactly is that Second Amendment command? We know what it is, that the right of the people to keep and bear arms shall not be infringed. All right? Well, I hope you guys learned something here today. Please double check to make sure you've subscribed. Some people say they've been unsubscribed, so please double check. Make sure you're subscribed. Don't forget to follow me on X at 4 Boxes Diner. And again, thanks for joining us here, and we'll see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.